Bună ziua tuturor! Numele meu este Mădălina Cotruț și astăzi voi modera această sesiune alături de colega mea Mirela Buliga, pe care probabil ne știți de foarte mult timp, de la cursul postuniversitar unde predăm împreună impozitarea nerezidenților și, bineînțeles, avem și invitatul nostru special, pe domnul profesor Malherbe, pe care îl avem tot așa prezent la cursul postuniversitar de impozitare a nerezidenților. Așa că, dacă aveți în vedere vreodată să vă mai înscrieți la acest curs, să mai auziți noutăți, discuții aprinse, noi vă așteptăm. Astăzi vom discuta despre antiabuz. Acest panel are, să spun așa, o sarcină destul de grea. Sper totuși să ne ridicăm la nivelul panelului anterior. Mai avem aici un membru din panelul anterior, sper să facă față și acum. Aș vrea, înainte să intrăm în discuțiile acestea despre antiabuz, să vă ofer așa un cadru un pic general, ca să înțelegeți mai bine ce vom discuta, pentru că în panelul anterior s-a discutat foarte mult de procedură fiscală și acum vom discuta cu totul și cu totul altceva. Și atunci aș vrea să vă fac o mică introducere. În codul fiscal, în titlul 1 și titlul 2 o să mă axez, o să avem puține discuții și despre titlul 6, deci sunt, să spun așa, subiecte care mă pasionează. Am preluat ceva și de la domnul Bufan cu antiabuzul ăsta, ne batem capul împreună, dar trebuie să vin și cu ceva în plus, ca să zic așa. Și ce vom discuta? Vom pune accent pe articolul 11, mirificul articol care conține aceste prevederi antiabuz și dă o competență, să spunem așa, autorității fiscale care câteodată nu o aplică cum trebuie, să spunem. Și mergem mai departe, avem și prevederile directivei anti-evitare introduse în titlul 2, în articolul 40. Știu, le-am discutat într-adevăr la cursul postuniversitar. Aceste prevederi sunt implementate ca urmare a directivei impuse la nivelul Uniunii Europene. Deci avem ceva în plus față de acest mirific articolul 11. Ce mai avem în plus? Mai avem prevedere antiabuz chiar și în cele două directive privind scutirea dividendelor și scutirea redevențelor și dobânzilor. Deci avem cam multe prevederi antiabuz implementate în cod. Ideea este că mai urmează și problema se pune ce facem cu ele, cum le aplicăm, cum funcționează ele, că sunt prea multe, și de ce mai avem nevoie de altele. Introducerea asta pe care vreau să o fac mă face să mă întorc un pic în timp, în 2012, când la nivel OECD noi vrem să devenim membru, ținem cont de ce se întâmplă la nivelul acestei organizații. Și atunci, în 2012, s-a întâmplat o răsturnare, așa pe plan internațional, să spunem, în care s-a constatat, de fapt, că multinaționalele încearcă să implementeze niște structuri în grup și obțin niște beneficii fiscale, ca urmare, ajung să plătească o cotă de impozit pe profit foarte mică. Cum au reușit? Prin erodarea bazei impozabile, adică s-au dedus foarte multe cheltuieli în statele sursă, unde au filialele, și apoi au mai beneficiat și de scutiri ale plăților de dividende, dobânzi, redevență, ca urmare a directivelor. S-a considerat că aceste beneficii fiscale, că au profitat de directive, le-au folosit cumva în alt sens decât au fost aplicate, decât se spera să fie aplicate de contribuabil. Și din 2012, la nivelul OECD, s-a introdus acel plan BEPS. Știu că ați auzit de el, dar vreau să fim împreună aici, să ne înțelegeți de ce vorbim de următoarele directive. Și prin acest proiect BEPS s-au propus mai multe măsuri antiabuz, preluate de directiva aceasta anti-evitare, pe care o avem în cod. La nivel Uniunea Europeană a ținut foarte mult cont de ce se întâmplă în cadrul această organizație OECD. Și lucrurile merg mai departe, se propune la nivel OECD, am ajuns să discutăm de Pillar 1, Pillar 2, aceste doi piloni, nici nu știu cum să-i traduc foarte bine în română, ca să sune bine, nu de alta. Nu știu, mi se pare ciudat, Stilpi. Ok. Și am ajuns să discutăm despre acești doi piloni, care ar urmări o reglementare a impozitării pentru aceste multinaționale care sunt digitale, și mai avem și o impozitare minimă, care această impozitare minimă s-ar dori să fie transpusă într-o directivă de impozitare minimă, adică statele membre să se asigure că orice companie care este înființată pe teritoriul său să plătească cel puțin un impozit pe profit de 15%. Deci cam asta e ideea. Și plecând de aici, această directivă încă este la stadiu de propunere, o să vorbească domnul Malherbe despre ea un pic. Apoi mai avem alte directive și problema care se pune este următoarea. O să avem din ce în ce mai multe prevederi antiabuz. Și după ce o să ne facă prezentarea domnul Malherbe, o să discutăm un pic, să vedem ce facem cu ele. Deci de asta aș vrea să aveți această întrebare când urmăriți prezentarea domnului profesor Malherbe. Ca și reguli așa organizatorice, prezentarea va fi în limba engleză. Dacă aveți întrebări ulterior, puteți să le adresați fie în română, le voi traduce în engleză, sau direct în engleză. Dar bineînțeles, în funcție de timp, domnul profesor ne ține timpul. So I would like to invite for our presentation Professor Jacques MALHERBE, our special guest. He is very familiar lately with Romania, and he is helping us, as I told you, also with the post-university courses, teaching taxation of non-residents and also EU tax law. And today he will tell us more about the latest developments in the European tax law affecting practice, the multiple definitions of abuse of law, and also highlighting some reporting obligations. So please, Professor Malherbe, you can take the floor.
Thank you, Mrs. Cotrut. And it's good to be back face-to-face in Romania after those years of absence when we saw each other only on the computer. But I've seen many of you on the computer. I want to thank the Academiei de Studii Economice and the Facultatea de Drept, the Universitatea de Vest din Timișoara, and Professor Buffan, particularly for their kind invitation. It's a pleasure to be in such a beautiful room. I don't think we have that at the University of Louvain, it's nice to be in those surroundings. What I want to do in a short time is to present you the elements, the new elements in European tax law, which can be of interest to you, especially as practitioners, because the proposals of the Commission today are the domestic law of tomorrow. And so we must get prepared. We shall see how and why. I am sorry not to be able to do it in Romanian. I can read Romanian, but I'm unable to speak it. But I thank my professor of Latin that thanks to him, I can read Romanian. So, first, I would like to cite only one recent judgment of the European Court of Justice. You know how important the decisions of the European Court of Justice are to practice. Of course, those decisions come only on a particular case. And so they are not a body of law, but we can try to make it a body of law by putting them together. That's what we have tried in a book in Romanian, which was published a few years ago, but which is already a little bit outdated. So, a very recent decision is the decision in W8G. It is a German judgment. The problem is the following, which we face in many countries. In Germany, the tax losses of a permanent establishment of a German company outside of Germany were not deductible. And so the company said, well, that's a discrimination, because if I have a permanent establishment in another German city, I can deduct my losses, and now, because my permanent establishment is in another EU country, I cannot deduct them. And the court said, well, that is the division of taxing powers between countries. And as in Germany you decide by treaty not to tax foreign profits of permanent establishments, well, you should not be able to deduct foreign losses. Another taxpayer said, yeah, but in other cases you seem to have decided otherwise. I shall not go into the details, because you can read the case, as you know, you take only on your computer Curia, and you can read all those beautiful cases. You don't, of course, take Curia of the Vatican, you take Curia of the European Court of Justice, and so that's it. Well, those other cases were different. Here we have a division of powers according to a treaty, so the court said that's something which we have to allow. And that's interesting for many countries, because in some countries, foreign losses of permanent establishments were deductible. It was the case in the Netherlands, it was the case in Belgium. And recently Belgium said, no, finished with it. And this means that in Belgian practice, we are now sure of the solution. And you will adapt it, of course, to Romanian practice. Then we come to the proposals. The first proposal I would like to deal with is a draft directive called the Debt Equity Basis Reduction Allowance. And as we have to use acronyms now to be snobbish in all fields of the law, it's called DEBRA. DEBRA has a dual purpose. First, rather strangely, it will create an allowance of a deduction for incremental equity in any type of company. This is an old system which has existed, for instance, in Brazil for a long time, in Belgium, where it's almost reduced to nothing. And so this is not, the idea is, according, for those who like economics, the theorem of Modigliani-Miller. You remember how to finance companies. Well, if you finance a company through debt, interest is deductible. If you finance it through equity, dividends are not deductible. Okay. So, in some countries, they said, well, you may deduct something when you pay dividends. And the proposal of the Commission is that when you increase your equity, so not for your existing equity, but for no new equity, you add capital to your company, then you may deduct interest computed at the 10-year risk-free interest rate in your country, plus a risk premium of 1% or 1.5% for small and medium enterprises. There is a limit. You cannot exceed 30% of your earnings, and you can carry it forward for 10 years. And of course, there is a decrease in your deductions if you reimburse part of your capital. And there are anti-abuse rules. So that's the first part of DEBRA. I wonder whether it will be accepted by the Council and by all member states, because it is a novelty. It is a novelty, and frankly speaking, I think it comes rather late. But the idea is that during the pandemic, our companies in the European Union became weaker because of loss, of course, of market power, and that we have to do something to avoid that they borrow too much, and hope that they will finance themselves through equity. The second part of DEBRA is a limit on interest deduction. And so there would be a denial of a deduction for 15% of interest which is paid outside of the company. You will say, well, we had already such a limit in the so-called ATAD directive, the Anti-Tax Avoidance Directive, which is implemented in all our countries. Yes, that's true. And there, you remember, it was a very, a very complicated system, 30% of EBITDA, and you had to make a computation. So DEBRA would be applied before ATAD. Again, I wonder why we need two types of legislation on that topic. I think we are suffering a little bit of over-legislation in the European field. Montesquieu, the good old Montesquieu said, you should touch laws only with shaking hands. Well, the hands of the European commissioners do not shake. They touch the legislation all the time. So this is DEBRA. And then we have the DAC 7 directive. Why DAC 7? It is the seventh modification of the Directive on Exchange of Information. And there also we see over-legislation, excess legislation, but maybe it is justified. It depends on the opinion you have on all the previous changes to the Directive on Exchange of Information. This one first introduces a few procedural provisions which may be of interest, especially after the very good speeches you had on procedure. First, the foreseeable relevance. You know that a country may ask information to another country's tax authority only if the information is foreseeably relevant. What the hell does it mean? Foreseeably relevant. Well, they say that you have to mention precisely the tax purpose of the request and the grounds you have to believe that the information is held by the requested country. So it is an improvement in precision of the request. And then the touchy topic of group requests. fishing expedition. You ask for information about a group of taxpayers. Well, you have to describe the common characteristics of a group. Of course, all the people who have a beard or all the people who wear spectacles are not a group. You define them. And then you must state again the reasons you have to believe that the group has not complied with the law of the requesting country. Yes. Yeah, the fishing expedition. So for instance, Professor Buffon and myself, after working, we shall go to Maramuresh. Is Maramuresh a group? No. So, okay. And then, we have automatic exchange of information on many topics, and this time we add royalties. Of course, I don't see why they were omitted, but that, of course, is justified. And then the directive speaks about platform operators. You know, eBay, Amazon, Alibaba, all those platforms. On those platforms, the operators operate, and finally, you don't know who they are. You don't know where they are located. And so they want to make them identifiable, what they will do for some relevant activities. And the relevant activities are the rental of real property, personal services, a lawyer who wants to advertise, I don't know whether lawyers may advertise, or accountants, the sale of goods, the rental of automobiles or other modes of transport, and investing and lending in crowdfunding, all this for consideration, of course, when you sell something. So, all the platforms present in the EU will have to identify the people who are using the services of the platform. Which platforms? Those platforms must have a residence in the European Union, eventually a permanent establishment. They must eventually, without residence or PE, facilitate the relevant activities or the rental of property. And you have to report their address and their taxpayer identification number or their VAT number. And you must report also the commissions which they are getting for their services. So you see important advances for the practice in that directive that will all come into Romanian law, of course. And then joint audits. Joint audits, it's a very nice thing because when you are a tax controller in your country and you get a little bored and the weather is bad, well, it's nice, I have a joint audit in Spain, and you go to the sun in Spain. Well, the procedure will now allow the foreign tax inspectors to take an active part in the joint audit. So far, so good. The tax inspector would sit there and listen to the tax inspector of the country asking the questions. No, he may be active. They will make jointly a final report which will have legal value. They will try to reach an agreement because they are there face to face, the Spanish and the Romanian. And they say, well, how shall we tax that person? So, well, they must try to go to a compromise.
Jacques, and they will speak English between them, the Romanian and the Spanish.
That's the feeble problem. I think that they will speak Latin, because otherwise I see no common language in Europe. But as English is the new Latin, you know, even in the Vatican they don't speak Latin anymore, they speak Italian. So, okay, so that was the DAC 7 directive.
Jacques, one second. DAC 7, DAC înseamnă Directiva de Cooperare Administrativă și vreau numai să vă spun ce mi-a spus Jacques din Belgia. DAC 6, știți că e o discuție în România cu DAC 6 că tu trebuie să te autodenunți, da? Jacques spune că în Belgia DAC 6 este Directiva SS, așa a fost numită, pentru că trebuie să te duci să te autodenunți. Și eu aș vrea să-l întreb până în final care e practica acolo, că la noi n-am văzut, eu le mai spun la unii contribuabili, mai vedeți că voi trebuie să vă denunțați și dacă nu trebuie să mă duc eu să le spun. So it will be a question at the end, how things are now yet in Europe with the SS directive, because in Romania it seems that nobody knows. Each body, the lawyers, the tax accountants would like to invoke the professional secrecy, you know, not to comply with.
I will come to that. I will come to my professional secrecy, to which I stick very much. Now, anti-abuse. I must confess to you that I was always an adversary of the use of the anti-abuse doctrine in criminal law and in tax law. I admit it very easily in civil law, but so far so good. I lost that fight many years ago, so now we have anti-abuse provisions all over. And I'll give you as an example the Belgian one, which is nothing really special. And here I will, of course, be much shorter than it's in my slides. I will come to the many definitions we practitioners have to apply of tax abuse. There are too many. I don't know whether in Romania your tax abuse provision is in the Fiscal Code or in the Code of Procedure. Probably in the Fiscal Code. Which is a fascinating document. It's not as big as the American one, but almost. It started with the Anti-Tax Avoidance Directive, and with the OECD model, and in the Anti-Avoidance Directive we have Article 6, which says, basically, no tax abuse. Otherwise, we shall disregard what you have done and we shall tax you according to the normal way of things. Article 29 of the OECD Model Treaty now says the same thing. Of course, it has not been implemented in all existing treaties, but it does exist. And then we have the multilateral instrument. That big thing, which is very difficult to read and to understand, but which has been signed by Romania and by all countries which have treaties in the world. I don't know how many, 150 or something like that. So it is compulsory when you sign the multilateral agreement to implement the article on tax abuse of the multilateral instrument. Of course, it applies only to treaties, not to domestic law. But the problem, and you know it, if your treaty doesn't say nothing about it, are you allowed to apply your domestic provision on tax abuse in a treaty situation, in a transaction between Romania and France? The answer of the OECD has always been, not always, but has recently been yes. Because tax abuse is part of the facts. And the answer of the learned scholars was no. Because tax abuse is not part of the facts, it's a law. Well, the discussion is finished, and now the OECD has won, and you may implement your domestic provision, even if there is a tax treaty saying nothing of tax abuse, and even if the two countries have not signed the multilateral agreement. And the OECD recommends, obliges you, if you sign the multilateral agreement, to introduce in your treaty the so-called PPT, Principal Purpose Test. It is said at the beginning of the treaty, this treaty does not have as purpose to allow treaty shopping, to allow you to pursue a purely fiscal purpose and to pick the best country which has a treaty with your partner's country.
Doar vreau să vă amintesc că MLI, instrumentul multilateral, va intra în vigoare și pentru tratatele semnate de România de la 1 ianuarie 2023. Deci vor fi modificate tratatele de evitare a dublei impuneri și vom avea acest articol 29, PPT-ul, inclus și în tratatele noastre. Deci mai avem în plus niște prevederi antiabuz, cam asta era ideea.
Tax abuse. Before all that, before the multilateral agreement, before the ATAD, Anti-Tax Avoidance Directive, and even in the absence of a domestic provision, is there a general principle of European law which prohibits tax abuse in the fields covered by European law? It may be European tax law, or the directives, or it may be in the situations covered by the treaty, freedom of establishment, or it may be in other fields of the law, consumer protection, what do you have, competition? Well, the answer is yes. The answer is yes, and in tax law, this answer was established by the old cases of Halifax and Cadbury-Schweppes, and we shall not discuss those again, except that Cadbury-Schweppes says, you may disregard a tax abuse if the situation is artificial. But if the situation is real, in that case it was a company in Ireland, it was really active, there you may not disregard it. And specific anti-abuse rules were introduced in the Parent Subsidiary Directive and in the Merger Directive. So we have those principles now of anti-abuse in European law. And then we could speak for hours about two cases which are called the Danish cases. And I shall not be too long on them because they've been much criticized. The Danish cases were delivered before the ATAD directive. So they are delivered on the anti-abuse provision of European law, the general principle. And the situation was fairly fairly simple. Danish companies had established as their parents Luxembourg companies. And those Luxembourg companies were channeling dividends or interest to third countries. Some of those third countries were tax havens, Bermuda. Some of those countries were not tax havens, the United States, for instance. And the question, and I shall be very brief, you can see all that in the slides, and in the many articles, studies which have been written about the Danish cases, the court said, well, it is an abuse if you distribute your interest or your dividends to a Luxembourg company which can do nothing with them because they must rechannel them immediately to other beneficiaries. So they are not the effective beneficiaries. So, and you say effective beneficiary, but that's a concept of international law, which you find in the treaties. Is that a concept of European law? Well, the court seems to say yes. Most people think no. You have to define a concept clearly. But okay, so they are not the effective beneficiaries, and so you don't grant the exemption for withholding taxes, for instance, in the country of source. And the second question in those cases is, what if finally the dividend of the interest lands in a country with which the country of source, Denmark, in our example, had a treaty, and a treaty abolishing the withholding tax. For example, the treaty with the United States. Well, says the court, in one sentence they say, oh, well, then it's okay. In another sentence they say, well, not necessarily, because you have to disclose, etc. So we are left there in a sort of uncertainty. So, if you are interested in the Danish cases, I shall be pleased to send to any of you, you give me your email, a list of about 30 articles which have been written on the topic, including mine, but which was written in a very obscure Brazilian book, which is certainly not available. Okay, then our conclusion is that we have too many anti-abuse clauses. You practice, and your client comes and says, I want to do this. Well, you say, well, be careful, because we have a national anti-abuse provision. We have a provision in the treaty, because it's a new treaty, Article 29 of the OECD model. We have the multilateral instrument. We have the directives, parent subsidiary, for instance. And finally, we have the general principle of European law. So we have really too many clauses, I think. It's, again, overly drafted legislation. I shall pass on those judgments and immediately go to DAC 6 very briefly again, because DAC 6 is not new. It's since 2016, but we begin to feel the effects of DAC 6 right now. Do we have, as accountants, as lawyers, to report? We are intermediaries. Do we have to report tax schemes which meet the so-called hallmarks criteria of DAC 6, which are transfrontier, and and which may be perfectly legal. They are not necessarily tax abuses. You may even have got a ruling of your authority allowing you to do this, but do you have to report it? Because it meets one of those numeral hallmarks. Well, we shall not go through those hallmarks, but I will share with you an interrogation I had a few weeks ago. Clients consult me and say, we have foundations abroad, and we live in Belgium. We would like to dissolve those foundations because they are dangerous tools now. Bahamas Foundation. DAX 6 or not? Do I have to report? What I'm doing is not creating a foundation. I'm dissolving it. And so everything will be taxable in Belgium. Probably it was already taxable because of the transparency legislation we have, so that's the type of interrogation which you will have to face after you read through all those beautiful hallmarks. And then comes the dispute as to professional secrecy, professional privilege. And we in Belgium, as in France, we are very sensitive to legal privilege. So we went to the Constitutional Court. Where am I now? To the Constitutional Court, and we said DAX 6 is against the Constitution and against the Charter of Individual Rights of Europe and against the Convention of Human Rights. Everybody has a right to legal privilege. And the Constitutional Court said, well, that's very important. We shall ask a question, a preliminary question to the Court of Justice. And so that's it. The case is before the Court of Justice. And you will say, only about professional secrecy. No, no, no. The Constitutional Court of Belgium went much further, and they said, well, you know, some of those concepts are very vague in DAX 6. What is an intermediary? What is a participant? What is a hallmark? All that is too vague. It's not good law. Enfin, they ask. And so, legal privilege and definitions which are very broad. So, let's wait. Maybe the whole DAX 6 will fall in two pieces. Or the answer will be, no, 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 we stick to DAX 6. The French Conseil constitutionnel asked also for some questions to the Court of Justice. And then finally, we have 2 years to get prepared to the directive on shell companies, which is the most dangerous of all for practitioners, especially for practitioners who set up holding companies. A holding company is a very useful tool. You put it in top of a group. What do you need to administer a shell company? A small office, a good secretary, somebody who can read and write, and prepare a balance sheet. That's all. Well, is that a shell company? A shell company is a company, of course, which gets financial passive income. There are exceptions, quoted companies, regulated companies, etc. That's not our problem. What happens when you have a company which gets financial income? Well, you have to report. Do they have premises? Do they have a bank account? Do they have directors who are resident in Romania, for instance? Do they have employees in Romania? Well, if that's not the case, there is a presumption that it lacks substance. That presumption can be rebutted, but difficult. You have to prove that you have some employees and that decisions are taken in Romania and not somewhere in the United States. And there are also exemptions. You may ask to be exempted if you do not reduce the income of your beneficial owner by creating the holding company. Your domestic law may exempt you. And then, if you don't meet all those requirements, you will be deprived of the benefit of all tax treaties and of all directives. It applies only to companies which are tax resident in the European Union. And so that's it. That's what we must look forward to. There is a last thing, but it's not yet a directive. It's a so-called BEFIT, the Business in Europe Framework for Income Taxation, which will reply the consolidated basis taxation. And there is a consultation open for it, so you may answer the consultation. You just open the website of the European Commission, but there is no text so far, so thank you for your attention to all those dangers.
Thank you very much, Professor Malherbe, and thank you also for sharing your experience from the Belgian point of view. We hope that you will be successful, you know, to make this DAC 6 to disappear from our lives. Unfortunately, this shell companies directives, I'm not sure if it will come. Of course, I'm wondering why do we need it? Because we have ATAD, we have their anti-abuse rules. We have a general anti-abuse rule, so that anti-abuse, that is general provision, yeah, should counteract all the structures. So why do we need this shell company directive? For me, it's all the time this question or surprise. It's exactly what you said. Now we are facing a period when we have too many rules. And we will face the, let's say, the risk that maybe those provisions will be used by the tax authorities, but not in the good sense, in an improper way. Please, Professor Buffoni.
Jacques, we want to know your opinion about the situation only of the Romanian domestic law. We are facing this problem. In Romania, we have two general anti-abuse rules. So one, which is in Article 11 of the tax code, which is named general part of the tax code, Jacques, and other specific, special anti-abuse rules saying requalifying some incomes in salaries, etc., in different parts of the code. So our code has a general part, Jacques, and the other parts are practically the former separate laws, you know, is maybe a codex, not a code, okay? So in the presence of a general anti-abuse rule and specific anti-abuse rules, what the tax authority is doing, they are using both. In order to establish a new tax to the taxpayer, they are invoking also the general anti-abuse rule and also the specific anti-abuse rule. In our traditional way to think as jurists, we say that specialia generalibus derogant, but we don't know if this is okay, because we are making in the court the challenge to go against and to try to find arguments also against the provisions of the general law and the provisions of the specific anti-abuse rules. And I would like to know your opinion if in a law, in a domestic law, you need also general and the specific anti-abuse rule, and if the answer is yes, if is allowed to use both from the point of view of the tax administration.
Well, you guess, Professor Buffon, what my answer will be. As you said, specialia generalibus derogant. So, if the legislator has introduced a specific anti-abuse rule, he wanted to regulate completely the situation which falls under that specific anti-abuse rule. So, I think that he may not then come and apply the general anti-abuse rule. We have discussed that in a conference in Lima, at the University of Lima. There is a big report on that, and that was our conclusion. Whether we are right or not, you will judge, but that's my opinion.
I will also add something. ATAD, if how it was implemented in the tax code in Title II, it relates to corporate income tax, so all the transactions that are actually requalified from the perspective of corporate income tax should use, this anti-abuse provision should be used, because from my perspective, Article 11 is so general, it applies to more titles than only Title II. So then if we go specific and general, then I would go to this Article 40.46, all these numbers. And of course, the idea of ATAD was to requalify the transactions that are cross-border, not the domestic ones. But how the directive was implemented, actually this anti-abuse also targets the domestic transactions. So that is indeed a battlefield, yes. So, are there other questions? Mai sunt alte întrebări? Neclarități? Ne iertați că o să depășim un pic timpul. Acum o să...
Am eu o întrebare.
Te rog.
For Mr. Jacques Malherbe, I have a question regarding the jointly tax audit. How this jointly tax audit would or should or could influence the map requests? If the representative of Romania, for example, in the example at the hand, Romanian and Spanish, if the representative of Romania said an opinion regarding that matter, how the taxpayer could challenge if does not agree with that opinion, if this could be also challenged in the map request or before, or bearing in mind the directive regarding the tax dispute. Thank you.
You are putting your finger on the most touchy issue in all those directives. They provide for lots of rights for the tax authority and almost nothing for the taxpayer. As Mr. Mattei was telling a few minutes ago, at the end of the story, before the court, you may ask for all the evidence, and you will get the request of the Romanian state to the Spanish state, and the report and everything. But if there is no specific provision in the law enabling you to challenge before an urgent court, an urgent matters court, the request of the Romanian state, you have to wait, and you have nothing as a right before the procedure is finished. Now, for the inspectors, of course, the Romanian inspectors, when they come to Spain, they must be provided with an interpreter so they can understand each other, and I'm sure that they will understand each other anyway, because there is, you know, the good spirit between all tax inspectors of the world. But that's it.
Thank you.
Alte întrebări mai aveți? Ok, atunci vă mulțumesc foarte mult. I thank you, Professor Malherbe, for your presentation.